August 14th at 10:30.
The court juggles overlapping hearings. Lawyers and the judge sort out scheduling chaos, revealing the hidden strategy in courtroom timing, delays, waivers, and pressure. This opening sets a procedural tone and quietly hints that timing can decide outcomes before evidence ever appears.
All right, we will see you then. We are adjourned.
Thank you.
Thank you. Mr. Bedell, can you hear me?
I can hear you.
We were running a little late on the other matter, so do you have time?
Yeah, I think so. I'm locked in this place all by myself. I had to figure out how to reconnect it, but
well, you
yeah,
did it.
I'm
So I'm glad to hear that. Ms. Rosenthal, do you have another case? Oh, yes, you do.
I do.
11:15.
I don't see
Jacqueline
the jail.
Duncan, but she's not here. Where is she?
She's in custody in Burnett. I guess I don't see them on the Zoom hearing, but
They are not on the Zoom.
I think someone tried to
Come in?
earlier.
Okay. Is this going to be a waiver, Mr. Rosenthal?
yes, Your Honor, and then just a brief question for the court on the older case that she's in custody in.
Nope, I can't bring that up. It's not on my calendar today.
Okay, I will figure out another way to deal with it.
All right, Mr. Bedell, I have to do a waiver.
Duncan's attorney waives a preliminary hearing, and the judge walks her step by step through what she's giving up. Every answer locks her deeper into the system. The tension lies in the word forever, a one-time waiver she can never undo. The judge then enters her not guilty plea and sets the trial date.
Of prelim, and then we'll be right to you, okay?
okay.
We will go on the record in the matter 25 CF 72, State of Wisconsin versus Jacqueline Duncan. The state appears through District Attorney Kevin Schmidt in person. Ms. Duncan appears in person in custody with counsel Joseph Rosenthal by video conferencing. We're set today in this matter for preliminary hearing, but Mr. Rosenthal, you stated that this will be a waiver.
Yes, Your Honor, I did have a chance to talk to my client. We did review the complaint and the facts that are being alleged. And she does understand the nature of a preliminary hearing and the burden the state would have to meet and is okay with a waiver.
All right. So, Ms. Duncan, you understand what a preliminary hearing is?
That's correct.
And you understand that the state has the burden to prove a felony was probably committed by you in Burnett County?
That's correct.
Do you understand that by waiving your right to a preliminary hearing, you are agreeing the state can meet that burden?
I understand.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, call witnesses to testify for you? He'd be able to look at evidence and put in evidence into the case and possibly discover things about the case, which could include defenses. But for today's purposes, you're waiving that right?
That's correct.
Do you understand at a preliminary hearing, if the state does not meet its burden as to the felonies, I could amend them to misdemeanors or dismiss them altogether, but you're giving up that right?
That's correct.
Do you understand that as a result of waiving the right to a preliminary hearing, this matter will be bound over to future proceedings, which could include a trial?
I understand.
Do you understand that once you give up the right, it is forever and you can't get it back?
I understand.
Has anyone made any threats or promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently and voluntarily.
That's correct.
I will find you are competent. You're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. We'll find probable cause and bind the matter over. Information.
I filed the information. It mirrors
The focus shifts to inmate Ricky Bedell. He argues that Wisconsin's detainer blocks him from Minnesota's work release and boot camp programs. His persistence exposes how paperwork and state boundaries trap inmates even when they follow every rule. An intense clash between rehabilitation hopes and rigid bureaucracy.
criminal complaint.
Proceed with an arraignment or set for another date, Mr. Rosenthal.
We can proceed, Judge. We acknowledge receipt of the information, waive any further reading, and enter pleas of not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. I'm going to guess you want something a little sooner because you're going to be filing something.
I guess that was in regards to the other case, Judge, and I'll just I'll circle back on that one. But
All right,
There's
then August 14th at 10:30. We'll set you August 14th at 10:30.
Okay.
All right, thank you.
Thank you, Judge.
We are adjourned. All right, Mr. Bedell, are you ready?
I'm ready.
We will go on the record in the matter 23 CF32, State of Wisconsin versus Ricky Bedell. The state appears through District Attorney Kevin Schmidt in person. Mr. Bedell appears by video conferencing from Stillwater Prison. We're set today in this matter for a resentencing hearing. So, Mr. Schmidt, can you please provide argument to the court, or has an agreement been reached?
So if you recall, Judge, at the last hearing, the court asked Mr. Bedell to get something from his caseworker indicating, there's some veracity to the claim that
The judge recalls the original sentencing intent and strikes a hard balance. She cuts Bedell's prison time to 1.5 years in and 5 out, concurrent with his Minnesota sentence.
this case is somehow preventing him from doing work release. He did provide something to the court. I'm trying to find the document number. Oh, sorry. I forgot there were so many letters sent.
I think I sent like 3 or 4 since our last hearing too, because I just kept finding new stuff and I didn't wait.
Yes, we
Send
have something filed on May 15th and 2 things filed on May 19th.
Yep.
I don't recall which file number it was, but one of them was a document from his caseworker indicating there are 2 reasons that he's not eligible for the work release. One is the Wisconsin detainer. The other is he just doesn't meet the security level requirements for it. And based off of that, I don't think the court can modify the sentence because it's not a new factor. It's not even a factor affecting the sentence.
My security has gone down to a
Mr.
medium.
Bedell, your security is what?
This dropped down to a medium instead of, it was at a very high.
Oh,
Star.
no, you can't provide facts. I thought your security was there and you were being,
Oh, no.
Oh, it says medium and it says medium's too high for that. That's the problem.
okay.
Let's see if I can find the case. Found it. It is document 97.
I have that in front of me. Oh, are you done with your argument?
Yes, the defendant has asked to lower their prison sentence so they can do work release in Minnesota, and his own documents say that won't happen if the court lowers the sentence.
All right, Mr. Bedell, argument?
Yep. Well, there's a few programs and work release. When that was dated, I was at a very high security min-star rating.
Relief meets warning. If this affects it, that's too bad. A perfect closing moment, mixing mercy with authority before adjournment.
And if you check the dates on them, there was one that was very high. And then after that, I've since dropped to medium, which is acceptable for work release, but I was held back for. And it's not just work release. Like there's boot camp, there's ICWIC, there's a few different programs. And I've sent the applications in for the one I sent in has this scribbled out. Like my caseworker was going to sign it and send it in. but yet he couldn't even send it in and he had to scribble out his signature because I didn't meet the criteria because I have a detainer in Wisconsin. And even as far as going to a minimum security prison, like right now, I'm being held in closed custody at Stillwater on an education hold. I'm actually medium custody right now, but I'm choosing to stay here. But in October, I turned to minimum status, but I wouldn't be even allowed to go to a minimum security prison with a detainer because they don't have fences on them. They give you an ankle bracelet. And if I have a detainer from another state, it doesn't allow you to be in an unfenced in area. I mean, I've sent in all the things that I want to do that are beneficial, don't allow me to have a sentence in Wisconsin or anywhere in any other jurisdiction.
All right. Well, I recall the sentencing hearing in this case. I recall that it was with Attorney Jim Renicky at the time, the DA at the time. We now have the DA here. As I put in my order granting the ability to be resentenced at the time of the sentencing, not only did the court, but the DA was looking at the fact of having something that won't be impacting your Minnesota sentence. And the court did place in my order exactly what was said at the sentencing hearing. The court said, I will make you eligible for boot camp so you could serve this with boot camp as well. So I'm trying to structure this where it's not going to impact or shouldn't impact your Minnesota sentence that you're serving, and it should still give you the oversight when you're released from custody. I'm trying to give more time after you're released, at least on my sentence. So if you mess up after that, you will be sent right back, but you'll be in Wisconsin prison system. So it's going to have more time on the outset after the fact that could be hanging over your head. So the intention and the intent at sentencing from both the state as argued as well as the court's intent in sentencing was to not have this sentence impact your Minnesota sentence and whatever you're doing there. So I believe at that time you indicated that you were serving a 5-year in Minnesota sentence. And then this sentence was to be less than that, 3